Welcome back. You're watching HFO-TV.
Welcome back to HFO-TV. I'm Greg Frick, partner here at HFO Investment Real Estate. Today we're going to talk with Charles Kovas, attorney, about some of the changes in the Washington legislative, proposed changes for Washington legislative that affect landlord-tenant law. So again, thank you for coming back. We've had you multiple times.
Thanks for having me, Greg.
So maybe give a little update as to where, we've heard a lot of stuff about Oregon. They kind of got fast-tracked a few bills through. There was Senate Bill 608. Maybe talk a little bit about what's going on in Washington, because that affects a lot of our clients. We've done a lot of stuff in Spokane, Vancouver, Clark County, and all the way up to Tacoma. What's the landscape up there?
Well, there were over a dozen bills that were initially introduced, and the vast majority of them fell by the wayside last week. April 17 was the deadline for the bills to get out of committee.
So they're not out of committee by that date. They are in essence dead.
In essence dead, unless a substituted bill is submitted after that.
Okay.
There were 4 that have passed as of this point. There's HB 1440, HB 1462, Senate Bill 5600, and the substitute Senate Bill 1582. Those are the 4 that have passed at the moment. We're going to talk about each of those.
And when in passing, do we mean they passed out of either the House or the Senate, and they still got to go, or pass?
Both the House and the Senate.
So it's sitting on the governor's desk.
That's right.
Gotcha. Okay.
So the first one, HB 1440, was relatively straightforward. It extended from 30 days to 60 days a notice of rent increase for a month-to-month tenant.
Okay.
Generally, if someone's on a term, a rent increase is going to have to correspond with the end of the term.
Right.
But with the month-to-month tenancies, the 60-day notice can be done at any time, and it's really just an extension of the existing 30 days.
And now, does that fall in line then with kind of Oregon's now 90 days?
Oregon is now 90 days.
Okay, gotcha. So we, at one point, Oregon was 30, I think it was 15, and we went to 90 days. Washington State's been at 30, so now they're at 60.
Exactly right.
Gotcha, okay.
The next bill is House Bill 1462.
Okay.
And that one provides for a 120-day notice of termination for cause where the landlord is demolishing or rehabbing the building, or they intend for a change in use, such as taking it out of the rental housing supply.
Okay, and so you can rehab, demolition, or change of use. You've got to give the tenant a 120-day notice.
That's right.
And to vacate. Okay.
Those 2 were the straightforward ones.
Gotcha.
The next 2 are much bigger and much more involved.
Now, before we go to on 14, are there any caveats on that in terms of, are there any exemptions or anything like that? If it's a single family, does it matter?
I'm not aware of any exemptions.
Okay, all right.
But I will state these things just came out of committee last week. So if I'm wrong, give me a chance to come back and correct it.
And then you can always get a hold of Charles, the information below. As like you said, when you deal with this legislative stuff, it's changing all the time. So, and a lot of times they, I know we're having that in Oregon now. They pass something, and there's some, the logistics of it. It just doesn't make a lot of sense for some people, and they think there may be some administrative changes down the road. So
that's right. Yeah. Particularly in Oregon, the bill was passed very quickly.
No amendments.
No amendments were allowed. 16 were proposed.
Yeah.
But I think it was introduced in the beginning of February, and it became law on February 28th. So they were not interested in massaging it to make sure it made sense.
Yeah. No, the lobbyists I talked to had said they don't remember seeing something kind of get slammed through so fast, and now we're, a lot of people in our industry are kind of looking at it, going, "Hey, wait a minute, there's some inconsistencies in this. It's not making sense." But again, hopefully we'll work through that in the next couple months.
That's what we're hoping for, and that's
keep you busy.
That's what lawyers are for.
Exactly.
All right. So Senate Bill 5600 is the big one that addresses regular month-to-month tenancies.
Okay.
Senate Bill 1582 is directed towards manufactured homes.
So just manufactured homes for 1582?
That's right.
Got it, okay.
But for 5600, there's a number of changes, and I'm going to try and go through those one by one.
Great.
The first is your 3-day notice for non-payment of rent has been extended to 14 days.
So a 72-hour notice is now a 14-day notice?
That's right.
And I can't do the math. Okay, so,
that's
wow,
right.
okay.
2 weeks instead of 3 days.
Wow, okay.
They did clarify that rent includes utilities and other periodic charges in addition to the base rent.
So that's clarified now in the law and the statute that is part of, if you're in default on those, that's included, where, like I said, in Oregon, it's a little vague on utilities. And
In Oregon, you cannot include those amounts in a 72-hour notice for non-payment.
Right.
But in Washington, you can.
Okay.
You can also include late fees. However, a court will not award late fees unless they're under $75.
All right.
So that's just one of the provisions of the bill.
Interesting. Okay.
So at court, if a tenant fails to appear and is found in default, the court will not award attorney's fees unless the total amount due is greater than $1,200 or 2 months' rent.
Got it. Okay. 1,200. Okay. So if it's under that amount, there's no attorney fees.
That's right.
Gotcha.
Where there's a default in rent, a court can delay the issuance of the judgment of restitution by 5 days. They no longer will issue it the same day that...
As the court proceeding.
That's right.
They'll delay it 5 days.
That's right.
Okay.
During that 5-day period, the tenant has a chance to either stay the proceeding entirely or cure it. And the way they cure it is by paying the amount due for rent and attorney's fees, if awarded, into court. If that money is paid into court in that 5-day period, the tenancy is reinstated.
Gotcha. And the attorney fees will only be if it's above that number.
That's right.
Gotcha.
The
Okay.
attorney's fees, again, are only awarded if it's above $1,200 or 2 months' rent.
Gotcha. Okay.
Now, if this happens more than once in a 12-month period
For the same tenant.
for the same tenant, each time, up to 3 times, they have to pay an additional $50 on the total sum they're paying into court. But once they have availed themselves of this remedy more than 3 times, it's no longer available.
Okay. So they can do the $50 payment 3 times in a year.
That's right.
Gotcha.
So after the first time,
Got it.
there's no $50 fee. After the second time, it's $100. Third time, it's another $150.
Okay.
But then after that, they can no longer cure the default by paying it into court.
Gotcha. Okay.
Now that's just one facet of this new rule. A court, on its own motion, or a tenant filing a motion, can request a 3-month stay of the judgment of restitution. And they do that by filing a motion that considers a list of following factors. The factors include willful or intentional conduct, exigent circumstances beyond the tenant's control, the tenant's ability to pay, the payment history, whether or not the tenant is otherwise in compliance with the rental agreement,
Other than the payment side.
other than that payment side, whether or not there are other notices of termination that have been issued or are outstanding, and this one's a catch-all, the relative burden on the parties. So for a lot of your bigger investors,
Right.
it's likely that a court is going to determine that that factor almost never comes into play.
Gotcha.
But for the smaller moms and pops out there who are relying on that monthly rent
For their
as part
mortgage.
of their
Right,
income,
right.
that's a factor that will more likely than not be in their favor.
Oh, okay.
Now, in addition, the landlord can apply to Washington's Landlord Mitigation Program that is part of the revised Code of Washington under Section 43.31.605.
Okay.
Your viewers may be familiar with that provision. That allows them to apply for a damage award of between $500 and $5,000 after they get a judgment.
Right.
That statute's going to be redone to include judgments from court for non-payment of rent.
Okay.
Now, the tenant has to pay that money back to the program within 3 months. There is no remedy right now for what happens if they don't,
but it's in there that they're supposed to.
but that is in there in the statute. The way the statute's written is that the landlord applies for that rent mitigation. If it's received, then the tenancy is reinstated.
Okay.
It's not written at the moment for the tenant to apply on behalf of the landlord, but that could be a change we see coming down the road. Now, once the stay is ordered, the court will require the tenant to pay not less than 1 month's rent into court within that 5-day period where the judgment of restitution is delayed.
Okay.
If the tenant doesn't pay that money, or if the landlord has applied to the landlord mitigation program and gotten the money, if that money is not paid, in either case within 5 days, then the landlord can go ahead and get the judgment of restitution issued by the sheriff.
Gotcha. Okay.
There's one other.
So this has added a little bit of time in terms of where it was before to where it is today.
That's right.
Yeah.
In essence, it's a response to the social phenomenon that we're in the middle of, where we're concerned about the lack of availability of affordable housing.
Right.
So under the factors that the court considers, if the tenant had the money and simply chose not to pay, then they're unlikely to get that stay.
Gotcha. Okay.
But ultimately, all these factors that the court's allowed to consider in determining whether or not they should grant the 3-month stay, all those factors are designed to protect low-income tenants.
Right.
And under the exigent circumstances factor, this will come into play where a tenant loses their job.
Medical emergency.
That kind of thing. However, the stay cannot last more than 3 months.
Gotcha.
So if the tenant can't make the payments within 3 months to the court to pay off the total amount, then after that 3-month period, the landlord's going to be able to get the judgment of restitution.
Right.
The last provision of Senate Bill 5600 is a new section which requires that any tenant payment of rent is applied to rent first, current rent and outstanding rent, before it's applied to late fees, damages, or
Other
legal
charges.
costs.
Got it.
That's
Okay.
right. That's been a provision in Oregon for the last couple of years. That is now a new section of the revised code.
Why? Okay.
And those are the changes from Senate Bill 56.
So for an owner, for an owner in Washington, the big change will just, it sounds like it's going to be the timing. You're no longer doing a 72, you've got a longer period for non-payment of rent.
That's right.
There's some clarity about what you can include for non-payment as to what charges are in there. And then there's the nuances of, getting a stay or not a stay, or a little bit more, maybe it's more open-ended, maybe it's not, depending on how you look at it. But there's, again, it could end up going, 21 and 90 days or somewhere in between.
That's right.
Okay.
But generally speaking, the stay cannot last more than 90 days,
Gotcha.
3 months.
Got it. Okay.
What I will say is that the landlord advocates did defeat the companion bill, House Bill 1453, and that would have required landlords to get receipts for all work done.
Yeah, I was reading about that. Yeah, that was,
And
yeah.
it prohibited the landlord from doing the work in some cases.
Right.
That part did not pass. So
Okay.
to the extent that Senate Bill 5600 included similar provisions on the stay and the tenant ability to cure a default for non-payment of rent, it's not nearly as bad as it could have been.
Gotcha. Okay. Interesting.
So,
And what is the timing? Do we have a sense? I know you're not up in Olympia, but what's the timing? Do they think the government, is there something, and is there an emergency clause on this to where it upon signature by the governor, it automatically goes in place, or is there time to?
that's a great question. The bill takes effect on June 30th, 2019.
Okay.
So after that time, the notice periods will increase.
Gotcha.
If you have issued a notice that expires after that date, it's probably going to be void.
So you may be better off issuing a new notice.
That's right.
Right. Okay. So so the 72-hour forms that people have used before in the state of Washington, there's going to have to be new forms for that.
Basically beginning middle of June.
Right. So because it will go beyond that date of June 30th.
That's right.
Gotcha.
A 14-day notice issued on June 20th is going to expire after June 30th, so it's going to be void.
Got it. Okay. Interesting.
And that is Senate Bill 5600.
Okay.
Senate Bill 1582 is actually an engrossed substitute bill, meaning the original bills didn't pass
But this
out
one
of
came in
committee,
place.
and this one was substituted in its place.
Got it.
Senate Bill 1582 applies to just manufactured homes.
Okay.
And that one similarly has a number of small changes. They may not seem small to the landlords who are affected by them, but the changes are going to weave their way through RCW Chapter 59 and affect a number of different sections.
Right.
So the first big one is that all rental agreements must be a 2-year term in a manufactured housing situation.
And right now, there's no.
Right now, it can be either month to month or a 1-year term.
So these will have to be a 2-year term.
Yes.
No month to month.
Unless you can have a month-to-month tenancy if the tenant is offered a 2-year term, but agrees in writing to a month-to-month tenancy.
So there'll be no more 1-year leases available on a manufactured home. They'll have to offer a 2-year.
That's correct.
If the tenant says, no, I don't want a 2-year in writing, then you can do a month to month.
That's correct.
Got it, okay.
And then, of course, the month-to-month tenancy goes indefinitely. But the main change here is that unless the tenant agrees to month-to-month in writing after being offered a 2-year term, all manufactured home leases need to be a 2-year term agreement.
Gotcha, okay.
Now, if a landlord is going to do a rules change, any notice of change in rules needs to be a notice of not less than 90 days that coincides with the end of a term.
Okay.
And the tenant must agree to those changes in writing.
So 90 days before their term is up, or 90 days before their 2-year term is up, there's going to be a rule change within the manufactured home park. They give notice to the tenant.
That's correct.
They have to agree in writing in terms, so not agree in writing of the rules change, or just agree that they've got receipt of them?
Agree in writing to the rules change.
Oh, okay.
The statute is unclear what
that mean
happens if they don't agree to the rules change, which leads us to believe you're going to have to file an unlawful detainer action if they don't agree to the rules change.
So that's going to keep you busy.
It will keep us busy.
Yes.
Now, a landlord has to covenant in the lease agreement that they do not intend to sell the manufactured home park within 5 years of a tenant signing a new lease. It is up from 3 years.
So every new lease that's signed in a manufactured home park, the owner has to covenant that he's not going to sell the park for 60 months.
Correct. Or convert it to a different use separate from manufactured housing. There are 3 exceptions. If there are circumstances out of the landlord's control, such as acts of God,
Eminent domain or something.
Eminent domain.
Okay.
Or if the property is sold to a tenant's organization.
Got it.
The last change is if the owner pays the tenant for the loss of use and value of the property during that period of time, then the landlord can do a 90-day notice.
Wow, okay.
Now, how do we know what those costs are going to be? Well, with the rental agreement, a landlord has to provide a 5-year cost history to the tenant that includes the rent and the utilities and other costs associated with the rental agreement.
For the previous 5 years?
That's correct. So
on every rental agreement?
On every rental agreement. So that way, the tenant will have that information
to justify whatever then, yes.
Exactly.
And what are they putting in for costs? Is that it? I mean...
Typically utilities, other fees.
Capital improvements, all that. Okay.
Correct.
That have happened in the last 5 years.
That's right.
As a way to estimate if...
But typically those are the tenant's costs. It's not necessarily the landlord's.
Right. So it'd be history of payment, if there's, not HOAs, but the, utility bills and things like that.
Exactly right.
Wow, okay.
Now, the next change occurs where the tenant wants to sell or assign the home to another tenant, a prospective tenant.
Right.
In that situation, typically the tenant has to give the landlord not less than 14 days notice. Not less than 7 days in advance of the proposed transfer, the landlord must consent or notify the tenant that they've denied consent because the tenant has not qualified. The new tenant coming in. The new tenant, correct. In this scenario, where the tenant's proposing an assignment or a transfer, a landlord cannot accept rent from the new tenant until the new tenant has received the rental agreement and the 5-year cost history.
Gotcha. Okay.
Where a tenant in a manufactured home has been evicted, or they have otherwise abandoned the premises, they now have up to 120 days to sell the home.
What was it before?
It was extended from 90 days to 100.
So the 120 days to sell the home on an abandoned, if they leave the premises, and they've got 120 days to get it sold.
That's correct.
Okay.
The last change is that your typical 15-day for-cause notice of termination in a manufactured home context has been extended to 30 days.
Okay.
Again, this is different from a 10-day notice in a regular fixed tenancy.
Gotcha.
This just applies to manufactured homes, and in that context, the 15-day notice of termination for cause has been extended to 30 days.
Got it. Okay.
And that is Senate Bill.
So there's some substantial
1582.
changes in there. I mean, this just in what we've just talked about here, the 5-year look back and the 5-year covenant. Are there other states that do that? Is that
Typically, no. I would indicate that these are the longest notice periods in the whole country.
wow? Okay.
I know that Oregon's 90-day no-cause notice is far and away the longest in the country.
It is. Yeah.
So I would suspect that the extension of the notice periods in Washington we're going to find when we compare with other states,
Right.
is a pretty dramatic extension.
Wow. Okay. Well, thank you for sharing those. If you have if you have questions, which if you have a manufactured home park or your management company does, you may want to make sure you've got clarity on this. And these go in effect?
Similarly, on June 30th.
June 30th. Okay.
And I would point out that these bills just passed on the 17th and the 23rd of this month, respectively. That's
Okay.
just yesterday.
I gotcha.
So there are undoubtedly more little factors in there that we have not covered.
Got it. Got it.
So I would urge your viewers to talk to their own attorney.
You can reach out, Charles, at the information down below. And yeah, so there's big changes coming in Washington Mobile Home Park management and operations in terms of what you need to do. And that's coming in June 30th as well as some of the stuff in the multifamily world. So
That's right.
thank you again for coming and explaining that again. It's always a moving target when we deal with some of the legislation changes. Hopefully some of the inconsistencies will get cleaned up a little bit, but until then, it will keep you guys really busy, I'm sure.
It sure will.
All right, thanks again. We'll see you again on HFO-TV. That was great, thank you.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.